First things first, obviously, if you've never been to our website, we do have a lot of other information on our website, and we do actually keep copies of these webinars. So you can go take a look at them after the fact, or have somebody else look at them if you thought it was really great and think somebody can use the tips that we gave. So take a look at this. Person who has the answer to every question must be available 24/7 to fix water leaks, fires, screaming homeowners, fireworks, threats, and all other problems. Must have eagle eyes to spot all covenant violations on inspections. You can keep reading, but I don't think any one of you probably signed up for this job description, yet I'm pretty sure every one of your board members thinks that, in fact, this is your job description and thinks this is what you're there to do. And I think many homeowners think so too, that you're going to fix everything because no matter what the issue is, community managers seem to get that call almost as often as the police do on some of the issues we're going to talk about today. And many, many times this is not yours and is something that you need to be very quick to fend right back out to tell them to call the police. And we're going to go through a bunch of these, but again, your job is not in the protection industry. You are not a police officer, and so many of these situations really are problematic, but they're dumped on you, and they're not something that's even within your authority. So let's be, the very kind of down and dirty is anytime there's a weapon, end, stop. Your answer to anybody at any point in time, if there's a weapon, is call the police. That is not your job. That is not in your job description. And you never should be putting yourself in that position. If you have a board meeting and somebody sees a gun, don't worry about whether or not you get to the adjournment, you get to the votes. Just get safe. Stop. I mean, that is your first answer to so many situations like this. If there's somebody injured and there's blood, there's any kind of injury, call 911. Nobody's asking you to step in and be the paramedic, to be the person in charge. If there's a person who's standing in your board meeting and they're threatening you, adjourn the meeting, walk out, leave him there. If you think you're going to have a threatening person at your board meeting, and we're going to talk about some options for you, but when you're being threatened, get to safety. That's your first answer to you, to the board, to anybody. If there is a hazard, you got homeowners telling you any of these things are happening, your answer is to tell them to hang up and call 911. These are not your issues. Damage happening right then and there. You need the police there because you're going to need a police report to demonstrate the damage. Maybe you're going to handle it later, but when it's happening right then, call 911. Same with fire. Normally, if it's an emergency, other than water, which it does fall in your categories, but other than water leaks, any of these emergency situations, not yours. Tell them to call 911. One of the things that pops up a lot of times for, questions for board members is, we're sitting there, somebody's hurt, shouldn't we do something? Well, trying to help is a good thing, and Colorado supports that, and there's a law, it's called the Colorado Good Samaritan Act, and it protects you if you try to give aid to somebody who's injured, because you have no duty to do so. You can see somebody getting hurt and you can walk away. I have many friends who see the sight of blood and they're likely to pass out right next to them if they try to help, because the sight of blood is not something they're capable of dealing with. And if that's you, that's fine. Then call 911 and get them help, and don't feel like there's a duty on you to step in and do something. If you do try and step in, obviously this law will help protect you in case something else happens, because you don't know what you're doing. So that's out there. So what we're trying to look at and what we're trying to kind of focus on today that are your kind of bread and butter, things that are getting called into managers, okay? We're seeing threats. We're seeing crimes happen within our community. We have one individual or another who will call the manager, call the board and go, do you know he's a felon and he just moved in? Maybe we're seeing situations that we think are dangerous and they're developing, and how do we handle that? We're seeing elderly who are moving into condos thinking they are assisted living facilities. They've got dementia or they have other issues, and we're seeing that. And we're seeing that kind of dumped on our plate as managers or as board members and attorneys. We're seeing more guns everywhere. And of course, there's always fire hazards, and they come from a variety of sources. So we're going to try and walk through some of these situations about what you can do and what you can't do, and how do you best protect yourself and protect your community, because ultimately, our main task, altitudes and our managers, is to keep our community out of harm's way. So we're going to try and walk through some of these. So lots of the threats that an HOA get are really empty threats. I'm going to call my lawyer, I'm going to get you, I'm going to make sure you lose your job. There's lots of them, and homeowners are frequently upset about the things that are going on, and they kind of spout off about this, that, and the other thing. And when they're doing that, there's really nothing to the threat, okay? So, but you have to evaluate each one of these threats so that we kind of know, what are we looking at? What's the issue, and what should we be doing with this? And the important things to look at is kind of evaluate them. So let's look at them. So a lot of homeowners make a threat against the HOA, right? They hate their HOA. And so if the threats are, I'm going to see the boards removed, I'm going to get you all voted out. Who cares? See you at elections, good luck. Really not a big threat, right? We don't care. That's their right to vote and vote in a new board if they think that that's appropriate and that's going to help their community, but it's not a big deal. It's political actions. A lot of them threaten, we're going to have the covenants revoked. I'm going to have this all disbanded. Give it your best shot, dude. Not an easy topic, not an easy thing to happen. And so those kinds of threats, we don't care. We really just don't care. Now, when the threat is, I'm going to burn down the clubhouse, okay, call the cops. That is a threat that one may end up in menacing charges against that homeowner, depending on whether the cops think there is that there's an action there, that they're really meaning it, or they may just go talk to them, right, and try and threaten them back. Don't make these threats. It's a violation of law, blah, blah, blah. So when you get that threat, they're going to take, violent action. Then you want to call the cops, right? You want to make sure that, and you want to record it by you, the HOA, sending a letter to that homeowner. These kinds of threats are actionable. We will turn them into the police whenever they happen, and this is not tolerated. I get it. There's no covenant that talks about it's a violation of the covenants to burn down the clubhouse. But if you get that, you want to document it in writing with a letter showing that you've told them that you're turning it into police, and do turn it into police. What about threats against the neighbors? The neighbor to neighbor threats, again, are going to be something that you're going to step back and say, hey, call the police. So when neighbor A says neighbor B is threatening you, then you're going to say, hey, call the police. I'm not the police. I can't protect you from your neighbor. If your neighbor's threatening you, you want to call the police. And the other thing is when you tell them to call the police, you want that in writing. Again, you want to stand out and make sure that at every opportunity, you, the manager, are creating documented proof that you told homeowners you're not going to protect them, that they have to call the police because that's who protects them. And you wanted that email in writing, so that if there's ever a question down the road, heaven forbid the neighbor B actually hurts neighbor A, neighbor A's family or neighbor A can't sue the HOA and say, I depended on you to protect me. You'll be able to say, no, I told you I can't protect you. I am not your first line of defense, and to call the police. I told you I couldn't protect you. So they can't say there was some reliance there. Many of the older documents do talk about safety in them. And so we really need to take every chance we can get to make sure that we tell our homeowners, if they say that they're afraid, that we can't help them, okay? Don't use the phrase, this is a neighbor-to-neighbor issue, right? That tells the neighbor that you're just not going to enforce covenants. And that's not really the truth. The truth is there's nothing in the covenants because they're getting threatened. That's a police action. So what you want to say to them is, I don't have authority to protect you. That's a violation of law if they're threatening you, so call the cops. And so again, you want to rely upon it's outside your authority, not you're just not going to help them because it's neighbor to neighbor. What about the threats against the manager? Okay, most of those are really kind of bizarre. I'm going to get you. What does that mean? You're going to get me fired? Sometimes that thought is, oh yay. Oh, sorry. Some of those communities that we're in when we have those threats against us, you kind of know when you hear it, it's bogus. But other times there's some concerns. If in fact you are getting these weird threats against you, you want to document them, right? Uh, uh, Attacks against you for no legitimate purpose can be considered harassment. And we're going to come to a slide and I'll kind of walk you through what the legal standard is for harassment. And so if you're getting those threats against you in email, you want to talk to the board, you want to talk to counsel, maybe look into whether or not you can prohibit this person from sending emails. If the emails are just threats, that's not a legitimate purpose. There's no need for you to worry about that. So maybe what you need to do is send them a letter going, you know what, we're not going to take your emails because they're abusive and they're hostile, so you can just send us snail mail and we're not going to deal with this thing. But again, you have to kind of evaluate it. What if they start following you around? Well, that's stalking, and that's, again, a police action, and you want to call the police. And, if there's any threat of violence, I'm going to make it so you can't walk into the courthouse. I'm going to make it so you can't walk around the community. I'm going to, whatever, punch your lights out. Threats of violence, immediately call the police. Amjag has pointed out a good point. If you have a neighbor A who's making racial attacks against neighbor B, you do have some FHA obligations in that regard, because FHA has said that if we, the HOA, know that there are racial attacks, we have to do what we can. Now, again, there's probably nothing in your covenants that talk about stopping one neighbor from calling the other neighbor names, especially racially motivated names. So what can we do? Send the person calling bad names a letter that says, that conduct is not appropriate. It will not be tolerated. We've directed neighbor B to turn you in to the Colorado Civil Rights Division and to the police for hate crimes, right? You're just going to put them on notice. We're not going to tolerate this. Now, can you really do anything? Probably not. But you've done what you could, so that's what you're going to do. You're then going to send a letter to B, the one who's being called names, and you're going to tell them, if you keep getting called names, call the police about hate crimes and call the Colorado Civil Rights Division and see if they can help you with charges against neighbor A, because you want to be in B's corner so B doesn't turn you in to the CCRD, the Colorado Civil Rights Division, for not helping them. Harassment on a public forum, we'll touch on that in a minute when we get to harassment. So let's continue down. What do we do when we get the threats against the board? Okay, well, it's kind of the same position as you, the manager. It kind of depends on what's being said. Is it, I'm going to get you recalled, I'm going to have you removed, I'm going to get rid of the covenants? That's all political, right? There's nothing there. What if they start defaming the board members? Well, unfortunately, in Colorado, the law says that all board members are quasi-public figures. And if you're a public figure, you have an elevated standard of proof to prove defamation. And so it becomes very difficult. And you have to prove that what they said then damaged the board member in some fashion. Again, very difficult because of the way the law has set it up. It's very hard to deal with defamation of a board member. So while the board members get very frustrated with it, there's not always a lot you can do about it. What about threats against vendors? Well, now here you may have a duty to step in and do something here, depending on the contract you signed. Because if you've called the vendor to come to your site, you have a duty to make sure he has a safe area to work. And if he's being threatened, you may need to be the person calling the cops to stop the threatening. You may need to be sending letters to the homeowners saying, leave the vendors alone. You have no right to talk to them, direct them, do anything about them. Because when you're talking about a threat to a vendor that you, the HOA, have hired, you have some duty to help him protect himself, right? And so that you may need to seek help from legal to get a letter out immediately to the homeowner. Stop talking to my vendors, leave them alone, work with the vendor so that the vendor doesn't feel like they're so threatened they leave your site, they don't do your work. There's all kinds of problems in there. Obviously, if they leave your site, then your work's uncompleted. There may be some clause and some ability to assess charges back against that homeowner making the threats. So you want to work with your counsel to try and use all the leverage you can to deal with any homeowner threatening your vendors. What about outside threats, right? That could be the neighboring community. That could be renters making threats. Well, if it's renters making threats, why does it make a difference? Kick them out of the board meeting. We don't care. They're not owners. Go away, people. They're not our problem unless they're holding the proxy of a homeowner, and then you're going to treat them just as if they were a homeowner and deal with the threats in that regard. If it's a neighbor threatening your community, again, you're going to treat it very much like the above items, which is, what's the threat? Is it a threat of harm? Is it a threat of something's going to happen? You're going to have to deal with those on a case-by-case basis, depending on what the threats are. Okay, so what about how the threat comes in? Does that make a difference? Only in a proof standard, right? It really, if they verbally threaten you or they put it in writing, either one is still the same threat, and you're going to evaluate it in the same way. However, it just gives you a different ability to kind of prove it in court. Obviously, if the threats are on the Facebook site, then that's going to depend if you can pull them down to get them rid of them. If it's on a site you can't get, then you want to make sure you can copy it so you have it as proof. But otherwise, a threat is a threat. Doesn't matter if it's verbal or spoken. And don't discard the fact that some threats are physical. If somebody holds their fist up to you and says, you know what this means, right? Okay, that's a threat. Was it in writing? Did he say, I'm going to hit you? Did he say, I'm going to punch your lights out? No, but he physically tried to intimidate you. Same thing. It's still a threat. Your testimony to a cop is going to show that's a threat. So how it comes in doesn't matter. And the issue, again, when we're talking about threats, is that so often you have no authority, right? Remember, covenants are promises that touch and concern the land. Somebody threatening to punch you really has nothing to do with the land, right? It's really so far outside of covenant enforcement that it's so much of the time not your issue. It's not something you should be handling. It's something, when you're talking threats, you're going to then be turning it over to the police. And oftentimes they're not even threats, right? How many times have you had a homeowner come to you as a manager, as a board member, that, one neighbor A comes in and says, neighbor B called me a bleepity, bleepity, bleepity. Well, it's rude. It's offensive, but it's not a threat. It's not a violation of law. There's nothing in the covenants that says people have to be polite. And it's not your job to be out there trying to stop rude behavior. That's just not what your job is. You have enough on your plate, as that slide showed, trying to just handle what comes in the door. You don't, have any, bandwidth for the most part to take on this stuff that's not your job. You're not their mommy. You're not there to teach them to be polite. And so again, if they're just being rude, they're just being rude. Police don't have any authority over that either. Okay. Now, what about restraining orders? We often get requests to get a restraining order on behalf of our clients because they are afraid. And there is a statute out there that helps us with that. A few things you need to remember. There has to be a threat of imminent harm. I'm going to break your legs. I'm going to punch you. I'm going to hurt you. If that threat is to a board member, then the board as a whole has to vote to take association funds to hire counsel to get that board member a civil protection order. It's an appropriate use of funds to protect the board if the board is acting on board's behalf when the threat comes in. Okay. What about a manager? The association cannot get a restraining order for the manager. Why? The statute says that a company may only get a restraining order for their employees. So the HOA cannot sue to get a restraining order for the manager, because the manager is not your employee most of the time. Most of the time there's a contract and you're a contract worker. And so say it's MSI, it's Hammersmith, MSI or Hammersmith could get a restraining order for their employees, but the HOA cannot act on the manager's behalf. Now, the HOA may vote to spend funds to hire an attorney to help the manager, but then the suit is going to be the manager against the person creating the threats. Okay, and that may be called for depending on the terms of the contract between the manager and the HOA. It just depends on what that contract says and such. And the other thing you need to know is the entire civil protection order, the entire process is set up so attorneys aren't needed. They're designed that way. They were designed to assist victims of domestic violence so that they could go into a courthouse, check the boxes, fill it out. They're forms that are created, they're at the courthouse, and you have to use those forms. Those are required to get the restraining order. And so the process is designed so that you don't need an attorney, and so you don't have to spend attorney funds to go get them. Go check your boxes, file it with the court. The court will then talk to you about what the threat was. You need to remember, if you decide to be macho after you filled out this paperwork and saying, well, I really don't think it'll hurt me, but just in case, you just guaranteed you won't get the order. Okay, just know that if you're afraid, you have to say that. You have to say it on the record. I'm afraid he's going to hurt me. I'm afraid she's going to hit me. I'm afraid they're going to do whatever. You have to say it on the record. If you say you don't really think they'll do it, you really won't get the order. So so make sure you know that going in. Last but not least, there's no fee shifting, right? So when you got that homeowner who is threatening you with harm and you've decided it's appropriate to get the civil protection order and you're going to hire the attorney to do it, you don't get to put those fees back on your ledger. Okay. So the question is, in a situation where we feel we need to involve legal counsel, can the manager expense this to the HOA, or do we need board approval for that? What if the board does not approve calling legal counsel? It is not the manager's call. It is always the board's call. So the manager doesn't get to make that call on their own. If a manager feels they're in jeopardy and the board says, I don't want to do it, then the manager can talk to their boss and ask their boss to go with them to get the restraining order, or just go by themselves and get the restraining order. But ultimately, it is the HOA's call. It is not the call of the manager. And so, you need to know that that's kind of how that works when you're trying to get that restraining order. Okay, so let's kind of look at some examples and try and work through them. They're pretty straightforward, but I think that when we talk them through, it makes a little more sense. So again, if you get an owner who threatens to beat up the manager or board member, that's sufficient to go get the restraining order. And then the question is just, do you want to go get it yourself, or do you want to have counsel go with you? I will tell you that, the initial request for the restraining order, the courts used to use, and this is past tense, but it used to be that they often would grant the temporary restraining order, which is then served on the homeowner. But then they raised the bar when you try to get the permanent. And the reason being is this: a restraining order has consequences on a person. So if you're an individual and you have a restraining order issued against you, there's consequences. You can lose your security clearance. Some jobs, you can lose your jobs. And so there's a lot of consequences. And because of that, a lot of people will fight very strenuously not to have a permanent restraining order. And so once you've got the temporary, you may want to talk to counsel about what's going to happen at the permanent. What are your options? Because a lot of the options on that civil protection order is you can agree to hold it in a temporary standard for up to a year, and then dismiss it if they've never bothered you again. And a lot of times you'll get people who will agree to having that temporary in place for a very long time to prove they'll never do it again, so that they don't have a permanent issued against them, because that would affect their job and their livelihood. So you want to be aware of that. When you're talking about owner threats to take care of the manager, take care. What's that mean? Going to get you fired? I don't know. It's probably not enough to get you a civil protection order. It's too vague. There's no proof of imminent harm about to happen. Now, if it's coupled with some physical actions, that might be sufficient. I had a person following the manager around and then making vague threats, and together the two things were sufficient to get the restraining order. So, but just take care of you, that's not going to be enough. What about an owner versus, the developer? We often see in newer communities where there's a lot of fighting and animosity between the owner and the developer over what may be a warranty issue, what may be a build issue, a punch list. And a lot of times what your action should be as the HOA at that point is to separate that builder individual is not the HOA, right? So owners got a beef. They're really mad, whatever's happening at their home, their beefs with the builder. And then you need to make that clear to them, because what you don't want is them assuming that you are one and the same, and you're not. And the lawsuit is different, and who they're going to go after is different. And so if you start seeing those threats, you really want to make sure that you can kind of clear up that the threat and the concern against the builder is the builder. Even if he is the declarant, he calling the builder. Explain to them the difference. What about a dispute involving board members? One of the comments is when managers had one board member who had a restraining order against another board member. That becomes almost impossible to deal with as the manager. But when you have board members who get restraining orders against them, that causes havoc in your, in your boardroom, because if that's the case, then only one board member could be present. Your other board member is going to have to be on the phone. Most of your bylaws are not going to take into account who do you keep, who do you make go home, what are you going to do in that? And that can be impossible situations. And you're going to have to reach out to legal counsel and work through what's in the bylaws, what authority do you have, what can you do. Again, if you have board members threatening others, there's possible liability to the HOA, right? If you've got a board member who's gone off the reservation, so to speak, and they're threatening other people, board members, managers, homeowners, you need to work with counsel to either get them to get off the board or settle them down, because they're going to cause liability to the HOA. And that, as a manager, one of your jobs is to stop that liability to the HOA. What about, owner to owner about noise or smell or smoke? Again, it would be nice if most owners talk to their neighbor first before talking to you and dumping it on you. Noise, smell, and smoke with HB 1137, there's not much we can do, right? If it's really loud, tell them to call the cops for disturbing the peace. Smell and smoke, there's just really very little you can do. Sometimes it's going to be a nuisance violation, in which case you're going to say to one owner, file the complaint with me so that we can move through the process and go that regard. Owner to owner disputes over parking. If one owner is parked in another owner's spot, again, if they're designated spots, that owner can have that car towed. That is one of the remaining allowances for an immediate towing, somebody parking in your space. But otherwise, if it's a complaint regarding a covenant, tell them to put it in writing. What about owner to owner about dog poop or barking or not on leash? You need to remember that, again, all the things on dog poop, barking, not on leash, those are those things that we're never going to be able to enforce right now unless they amend 1137. Those are going to be things where you're going to be telling the homeowner, call the Humane Society, call the animal control, go, deal with the fact that there's somebody else that's going to have to take that on, because you, the HOA, can't. Because unless that dog poops there for 30 days, you don't have a case. And if it's not barking nonstop for 30 days, you can't proceed with 1137. So remember, you need to take care of that. Remember, sometimes if you've got board members involved in these threats, they're going to need to abstain. They're not going to be able to vote because of the requirement for impartial decision makers. So make sure that when you're have these situations, you can deal with it. We kind of already talked about this, which is the Fair Housing Act complications, which is one resident threatens another resident, and there's racial implications, because Colorado also includes sexual orientation. If there's those kinds of threats within the threats, then you need to do what you can. And again, it might just be a letter to the threatening person and a letter to the person who's being threatened and trying to say, look, guys, we can't do much. Here's who can, and pushing it off. At what point does a neighbor to neighbor issue become a discrimination issue? Again, unless the connotation is one to sexual orientation, or it's in regard to their race, it's not going to fall under the FHA. And calling each other cuss words and bleepity bleeps, that's not discrimination. That's not your problem anyway. And again, if they're just yelling at one another, until you hear the word where they actually call somebody a racial epithet, or they said something about their sexual orientation, it's got to be specific. It's just one neighbor yelling at another neighbor, and you're going to tell them to call the police because it's nothing you can handle. It. You have no authority. If they get into the racial, if they get into the sexual orientation, again, you're still going to have very little to do with it. You're going to tell the person who's being threatened, call the police and tell them it's a hate crime. Okay, and that's going to come up. We're going to talk about that in harassment. And so when we talk about harassment, again, everybody looks at harassment as I'm annoyed, younger brother is harassing older brother. It's harassment, right? But that's not what the legal term is, okay? The legal term is significantly different. And this is the statute in Colorado. This is the legal terminology, all right? So striking or shoving, but not doing damage, right? There's no bruise, you just shoved him. That's harassment. It's assault when you hurt them, okay? So that's the distinction in Colorado. We're not going to talk about, the directing obscene language, because again, when they're talking that kind of obscene language, it means patently offensive description of the ultimate sexual act, right? Okay. Most times we're not going to fit under obscene, whether your board member thinks so or not. So most of the times that's not going to happen. Sometimes it's harassment because you're following a person in or about a public place. Stalking is under the harassment code, okay? But most of the time what we're going to see is going to be E or F, right? And maybe G. So we're directing communication. I'm sorry, it's not E. We're going to talk about it. That's the one that isn't going to happen most times. But that one's the one that came about and was because of Facebook posts and such like that. Occasionally we might have that, but if it's our Facebook, for the most part, we're just going to take it down. We're going to talk mostly about harassment when it's the phone calls where it's meant to ring with no purpose of legitimate conversation. And that becomes a really important part of that statute, no purpose of legitimate conversation. And so let's say you've got Mrs. Smith, and Mrs. Smith comes to every single board member or every single board meeting, and every meeting she raises the same issue. And every time you've told her, that's done, we're not talking about it again. We need to write her a letter and go, we're done with this. We're not going to discuss it anymore. Any further discussion about this, there's no legitimate reason, because we're done. Now you've put it in writing. This issue is done. We're not talking about it anymore. So now when she keeps calling, keeps showing up, you can make a claim to the cops. This is harassment. Now, whether the cops are going to take that claim or not is going to be selective, and each time it'll be determined on the different police department. But you can look at it in that regard that, here's the harassment, and you can quote the language of the statute and tell her it's harassment. And that might get Mrs. Smith to let you go. What about the board member that claims another board member have violated state laws? It sounds way too factual intensive to kind of jump through right now. I'm sorry. You're welcome to call me after, but that's way too fact intensive to kind of discuss how that's going to happen here. Let's talk about when the owners are harassing the manager or the board member. What you want to do is, when you start getting these emails, and I had one who would send 30 a day emails, clearly going to be harassment, right? Clearly it's not a legitimate purpose if you're sending 30 emails to the manager or 30 emails to the board member, or 30 calls a day. Okay. I think you're going to very easily meet the standard of harassment. And so what you want to do is, have your lawyer send a letter saying this is harassment, It needs to stop immediately. We're not going to accept your emails. We're going to block your emails. Now, if you're in a condo or a townhome, you have to provide an ability of that homeowner to contact you guys for an emergency. And so if you send a letter saying you've got to stop contacts, this is harassment, we're not going to tolerate it. You may only contact this phone number for emergency. And an emergency is a water leak only. Right? If it's a fire, you're calling the cops. We're not taking any more of your calls. We're not going to take your emails. If you've gotten that 30 a day, you can very clearly make the case that this is harassment and you can shut them down, but you have to allow them access on the emergency. You still have to allow them access to the board members, but you can reduce it to snail mail and you can tell them we will only answer once a month. Hi, we have other people to deal with. You cannot monopolize us. We are volunteers and we're going to limit this. And so you can restrict it. You have to allow them one way to do it. If they start abusing even that, you can work with your counsel and say, look, here's what's going to happen. You're abusing even this method of communication. So we're going to have you communicate through the lawyer. And by the way, we're going to bill you for the lawyer's time. That should shut them down. But again, that's, it's a process and you have to take it step by step so that you show the court we only did what we had to do so that we could continue maintaining our, work for everybody else in the community. We can't let this one person monopolize all our time. We have other jobs. And so you have to take it step by step. First, stop doing this. Then you're going to say the emails we're going to block your email, but we'll allow you snail mail. And then when the snail mail's too much, then we're going to block that too. You can go through counsel and we're going to bill you for her time. But again, step by step, show the court we only did what was absolutely necessary so that we could continue to do our job to the rest of the community because we have to respond to more than one homeowner. Okay. If you're one, I wouldn't give out your cell phone. Because they're going to blow it up. But again, it's the same process. You're going to say, block them from the text, move them to email. If the emails are blowing you up, move them to snail mail and then move them to the lawyer, step by step by step. At board meetings, again, kind of the same process, which is hear them out once, then tell them we're done. We're not going to hear it anymore. Owner's forum is for open matters. You've been heard. We're not hearing it again. That's not, it's not legitimate to bring it up every board meeting for, 2 years. No, we're not going to let you do that. If you have the harassment at the board meeting where they're yelling and screaming, kick them out. Tell them to leave. If they don't leave, you have to stand up and leave. I know it's annoying. I know it's a waste of your time. You guys have better things to do. But if you are at an in-person board meeting and you've told somebody to leave and he refuses to leave, the only way to do it is adjourn the meeting. Stand up, walk. Okay, it's the only way you can go. The other thing is the next month, because he'll probably come back, either move the meeting to the police department so that when you stand up and tell him to get out, you can walk down the hall and ask an officer to come escort him out, or hire an off-duty police officer to be there so that when you call him out, you can have a cop escort him out. That way you take care of it. Some other things you can do sometimes is successful is we've seen that if you have the meeting at a church, people don't like to yell at a church. I don't know why, but they're more polite at church. Again, you can, try and take some little steps to deal with it. Question, does this apply to a business phone line? Again, if you've told someone to not call you again, write down his number. When the call comes in, let it go to voicemail. Don't pick up the call. I mean, most of us on our business lines all have what, you can see who's calling. Don't pick it up. Can you remove them from an online meeting? Yes, you can remove them from an online meeting if they have violated your code of conduct. Say, I'm disconnecting you because you violated the code of conduct, so goodbye. And if they try and dial back in, don't let them in. What about outsider threats? Again, these are going to be the renters, and most of these are not threats of harm. And so, we're going to talk about what happens when you think somebody's committing crimes in your community. And that becomes one of the more pressing concerns for most of our communities, obviously. So what happens when you have car break-ins in the HOA property, and you think it's a certain tenant or a certain owner. You know, you need to be careful. You need to keep your board members to be aware that, you know, you, the manager, are not going to pass on to the police that we think it's tenant A or owner A. If an owner in your community thinks another owner is committing crimes, you, the manager, need to tell them, call the police. I can't call the police for you because that would be hearsay and the cops don't want hearsay. The cops need to hear from the person who has seen whatever evidence it is that they believe there's something and they can point to the person who's doing it. They need to hear from that person direct. So when those homeowners come to you and say, you, the manager, you, the board, need to call the cops, your answer is, no, I don't. I didn't see anything. You do. Cops need to talk to the person who actually saw something. Same thing with vandalism. If you've got vandalism happening in your community, you know, you consider putting up a camera to watch it. If you do put up the camera, make sure that you are putting up signs that tell everybody that, in fact, you are not going to watch that camera. It is not monitored, because you do not want someone saying, I relied upon that camera for my safety. So you need signs up to let them know it's not monitored, it's kept, and it's turned in for, you know, evidence or whatever. But again, you got homeowners who are frequently going to tell you they're certain their neighbor's doing drug deals. Great, tell them to call the cops. Not yours to deal with. You're not going to go investigate a drug dealer, and that's not something you're going to get involved in. What about dog bites? Again, tell them to call the cops. Whether or not you're going to remove the dog after the fact is separate. When it happens, it needs to go through the police department or animal control, and then you can look at your covenants, and if your covenants prohibit vicious dogs, then you're going to demand their removal. But start with the cops, start with the animal control on the dog bite, get the record by an outside objective party, and then you can follow up after the fact. If there are reports of crime in the HOA, does the HOA have an obligation to send out a communication to the membership? No, you do not. And in fact, if you do start doing that, then the homeowners are going to say, we are dependent upon you to continue doing so, and when you stop doing so, and then we got broken into, it's all your fault because you didn't tell us it was still happening. So once you take on that responsibility, owners expect you to continue doing it, and it becomes this thing that they're relying upon and creates more liability for the HOA. So the better course of conduct is for the HOA never to take it on. If it's happening, it's certainly great to send out a newsletter saying, hey, you know, if you're concerned about things like this, here's a location, here's a website of the police, here's a place that you can check to see if it's happening inside the HOA, and make it the owner's responsibility to be vigilant on their own, protect themselves, and be aware. You know, again, anything inside the unit generally is not going to be something we can deal with because we didn't see it, we didn't know what happened, and we don't even know which person's the victim. Is it the owner? Is it the tenant? Again, inside the unit, it's very difficult and almost impossible for you guys to handle or do anything with. Again, be careful about installing cameras because you need to make sure that that doesn't become a liability of the HOA. You know, again, for the most part, any noise complaint, any threat of violence, gonna call the cops. Towing, we all know because the law last year changed and we have to jump through all the proper hoops, and towing is significantly really reduced what we can do. Immediate towing is almost non-existent unless it's in an actual fire lane marked by the fire marshal. Be careful. I have a lot of communities assure me it's a fire lane, but when you confirm with the fire marshal, they go, no, it's not. And so if you're calling it a fire lane and the fire marshal isn't, it's not going to fall within that immediate tow provision. So make sure you, before you start doing immediate tows, that you know it really truly is a fire lane. Again, the police, any threat of weapon. Harassment, absolutely. There is a statute, use it. Let the cops help you where they can. Oftentimes the cops can just go have a conversation with the person who's blowing up your phone or blowing up your email account, and that will back them off. I've had many homeowners where we've turned it in to the cops, and the cops like, would you like us to talk to him? Yes, please, would you? And it stopped. Cops talked to him, we're done. It was awesome. So I mean, again, definitely do that. What do you do about a car crash on HOA property? Call the cops, because what you need is you need the police report. And even more importantly, you need to make sure that that police report lists the HOA as a victim, because once you're listed as a victim, the DA is going to try and get you restitution. And that means you're not spending your dollars to try and collect from somebody who's outside your community, because there's no fee shifting if that person doesn't live in your community. So if they crash and damage HOA property, can the HOA sue? Absolutely. Even if they don't have insurance, but you won't get your attorney's fees for suing somebody who's not in your community. But if a DA sues and gets you restitution, now somebody else spent their attorney's fees, meaning your tax dollars paid the DA to get you restitution. So make sure that if there's a car crash, it's on HOA property, there's HOA damage, the HOA is listed as a victim in the report. Animal bites, again, at-large barking. These are things that we have to use the police now because, again, HB 1137 is not going to get us anywhere. Again, you always want to stop when you get those calls. Too many times as a DA, when I used to be a district attorney, I had the little lady next door, who said, oh, I know this guy's a drug dealer because of all these people coming and going. Well, come to find out, people were coming and going because he's running a business out of his house. That may be a covenant violation, but it's not the police work. And so you don't want to be the person who's calling the cop going, well, the neighbor assured me he's a drug dealer. Make the neighbor who's certain he's a drug dealer make that call, okay? If you are overreacting and you're constantly pointing out things that really aren't a crime, cops are going to discount. I mean, cops are really short-staffed in most of our counties in Colorado, most of our cities. And, if you're overreacting, they're going to go, oh, yeah, whatever. They always say this. And you're going to get put on the bottom of the list, and the wait is generally long enough. So make sure that you have the people who are claiming something's happened be the people who call the cops, okay? And make sure that if there is something that's unsafe and you're calling the cops because there's a danger, make sure that you know who did it and you've got the facts to prove it. Remember, when the cops show up, they're going to think the manager's a landlord, right? They don't know HOA obligations, HOA law. They're not going to know the difference. They don't understand your position. They're going to ask you for keys to the unit. If you're a condo and happen to have keys to a unit and the cop asks you for it, do not give that to them. You do not have authority to let the cops in unless it is a fire or it's a water pouring down the unit and we're trying to stop the water, okay? You don't have authority to let cops go search. So your reason for having a key in a condo is for fire or water issues. It is not for the cops. If cops need something, they can go get a warrant. That's their job. If there are reports of crime in the HOA, oh, we already went over that one, sorry. What if a homeowner is asking about an update on another homeowner's violation or illegal activities? You're going to respond to them that Section 317 of Kiowa says that you don't give one owner information about another owner. What if a car is parked in front of a garage blocking another resident from getting out? The individual resident whose driveway is blocked can call and have that car towed so that it's no longer blocking them. And you'd rather have the resident who's being blocked call the tow company, not you, the HOA, because what if you were assuming the car's blocked and trying to be helpful and it's the owner's friend? Make the owner make that call. He's the one who can say, I can't get out of my driveway, and have somebody come tow him. We frequently have HOA members request that HOA to hire security patrols. Say no, just say no. Once you take on that responsibility, if you miss something, if security doesn't catch something, you've just taken on their protection. Now you've made yourself a target if they get hurt. It is not, again, you don't want to get in the job of taking on more obligations because you're creating liability for yourself. So, it's one of those things that you don't want to do. If you do have a situation where you think a crime was committed in the HOA, not they were arrested on HOA property, because that's completely different, but you think the crime happened in the HOA and you think it was by a tenant, get the police report and then send the police report to the landlord if it's a tenant. Okay, that way you're not making the accusation. You're just providing the police report that has the police's determination in it, and you're giving that to the owner. What you don't want to do is come between an owner and a tenant. You could be sued for tortious interference. If you're just letting the owner know what the police report said, you didn't make any claims, you didn't file the report, that's not on you. They can't sue you for tortious interference. Okay, so you want to make sure that you're being not going to put yourself or put the HOA in liability. What other things are we seeing? We're seeing fireworks as an issue. Again, HB 1137, something has to continue for 30 days before you can take action on it. So the fireworks aren't going to take place for 30 days. You're going to have to rely upon the county or the city police that hopefully have a ban on it and call it out. People yelling and being foul. you're not the rudeness police. That's not your job. Now, if they're yelling and screaming at 1 in the morning, call the cops for disturbing the peace. And so when the homeowner calls you and says, this guy's been yelling, tell the homeowner calling you, the manager, call the police. Again, not something you can do much for. If in fact the police come out, now you're gonna have a police report. You can use the police report to send a violation if you have like a quiet period, if you have quiet hours in your rules that, everybody has to be quiet after 10. You have a police report. This guy was screaming and yelling at midnight. Great. Here's proof. It's an outside person. Now send the covenant violation. And we all know it doesn't continue for 30 days. So all you're going to get is that one notice. And so again, you want the police to deal with it because they're going to either fine him or cite him for disturbing the peace when you can't do much with your covenants because of 1137. Same with loud music. Same with throwing things from the balcony. Again, while those things are going to be, you can send the notice, but you're never going to follow through and get to fine stage because of 1137. Okay. Do we need a police report to enact the 72-hour threat to public safety rule? Well, okay, where's the public safety? Somebody's yelling at 2 in the morning. There's no public safety. He's just loud and obnoxious. Loud music. There's no public safety. He's just loud and obnoxious. Throwing things from the balcony. Yeah, if he throws things every day for 1137 or throws things every day for 3 full days, great. Cite him as, a violation of threatens public safety, and then fine him or turn it over to your lawyer to take further action if the throwing things continues for 3 full days. Again, the relevance of 1137, I'm getting questions on that, is that the statute, Kiowa, section 209.5 was changed, and it basically says that you can only fine if a violation continues for more than 30 days. And you have to give them 30 days to fix it unless it's a health and safety issue. And if it's a health and safety issue, you only have to give them 3 days. But again, you're not going to have much teeth because you're never going to get to fines on all these things. You can send them the first letter, sure, but you're never going to get to the fine stage unless it goes more than 30 days. What do you do with the kids and vandalism? If in fact you can track where they live and they are within your community, and that's always the kicker, right? So we had 4 kids. We saw them do it. We got pictures of them. Who are they? Where do they belong? Do we know what house they belong to? You can't connect them to the unit. There's not much you can do other than to file a police report for criminal mischief, because that's what it is. Somebody comes in your property and damages it, it's criminal mischief. And so leave it to the police. Now, if the police then can tell you who the kid is, and that kid lives in your community, now you can go after the owner under your covenant saying you damaged the community. Here's the police report showing it was your child that did the damage. Here's the amount of damage. Here's the section of the covenant to say you're now responsible to pay us for it. Pay us for it. So you want to be careful with that. Obviously, if we're having lots of vandalism around the pool, around areas, the instant answer most people want to do is create some rules about it. Make sure the rules are not specifically addressed to kids. Make it addressed to everyone. No vandalism. If this happens, this is what steps we're going to take. Tenants, what can we do with the tenants that are, causing the disturbances? You have to send a letter to the owner, right? That's the key. Remember, you don't have any right to contact the tenants directly, even if you know they're the ones doing these problems. Your remedy is always against the owner, not the tenant. Damage to the association property, call the police if it's vandalism, get a police report, call your insurance. Again, a lot of times your insurance will work with the police to go after the other party's insurance. That you need to work with your agents on that. You need to know what the amount of damage is. Is it higher than your deductible? Do you want to create a claim or not? That's something you have to walk through with your counsel and your agent over whether or not you file that as a claim. Again, most of these things, call the police. One of the things that frequently comes up is neighbors see SWAT. They're staging, they're going to go in a house, they're going to grab the guy and they're going to take him out. Okay, well, make sure he doesn't come back. Why? How am I going to do that? We don't know why he was arrested. We don't know if in fact his arrest was about a crime in the community. If his crime was robbery of a bank, That didn't happen in the community. So the fact he was arrested in your community doesn't make it an issue or a covenant violation, right? Now, if SWAT comes in and there's damage to the unit, the damage is actually going to be the owner's problem to fix. And so you can send letters demanding he fix the damage, and he can take it up with SWAT over who's going to pay for it. And most of the time it's going to be the owner who's going to pay for it. But again, just because somebody's arrested in the community does not mean that, in fact, the violation happened in the community. You can get the police reports. Police reports are public unless the crime is against a child, and then it's heavily, heavily redacted. But you can go get the police reports. You can figure out what happened, figure out why he's arrested. If it was crime in the community, then if your covenants say any crime in the community is a covenant violation, use police report as your support and take action as best you can to either tell the landlord to remove the tenant if he bonded and came back. Okay. What about criminals moving in? Association really can't control who buys in your community, right? We don't know if, the next guy buying a unit has 4 felonies. You don't know that. And that's really not something that you can control. And generally only sex offenders have to be registered. So there's no real law that's going to stop somebody just because they have a criminal history for moving in your community. And HOAs don't want to get in the business of sending out notices when they find out somebody has moved into your community. Why? Because if they move into your community and you miss it, and you had started sending out notices every time this happened, and you've now missed one, if that person hurts anybody, you have just created liability for the association, right? Don't take on a responsibility that's not yours. If you think there's an issue, put it in your newsletter. Here's where you can look up, sex offenders. They have to register. You want to know if there's sex offenders in our community. Here's where you can look that up. We're not going to track it. If you, the homeowner, want to, you may. We can't stop them from moving in. So this is what you can do. Don't take it upon yourself to start sending out notices. We have a nuisance design guideline, but should we have a public safety design guideline? I don't know that it's worth your time to have a public safety design guideline. I mean, again, most things that are a public safety issue are a police issue. They're not a covenant issue. The only thing that is, for the most part, going to be an HOA safety issue that's probably something you're going to take on is a water leak. Upstairs is leaking to downstairs. Definitely a hazard to the downstairs, definitely a hazard to the property, to the community, to both units. And that's about the only thing you're going to jump into for the most part. That's a safety issue. Anything else that's safety is going to be call the cops. And so don't take on more than is yours. Again, another slide. Don't take on. You're not parents. I had a community one time, had a little lady who had dementia, and the board wanted to take her lunch all the time to take care of her. Don't take on responsibilities that are not yours, because if you fail at it later, you're going to be held liable because you started doing it and then you stopped. Lots of times, we have older people who are working and we're not caregivers. Managers aren't caregivers. Board members aren't caregivers. That's not your job. It's not your job to inspect if they turn off the stove. It's not your job to inspect if they're living in good conditions. It's not assisted living. It's a condo. A lot of time board members want you to call the family members. Remember, that homeowner has a right to privacy. You don't want to intercede in that. You do not want to get involved in that. Many times, I've seen board members want to reach out to family members and start getting threatened with lawsuits for sharing information that board member had no right to share to family members. So be very careful. It's not your duty to monitor. It's not your duty to assist. If they start doing things that violate your covenants, then you can take action. If you see that, in fact, they're hoarding, that's a hazard in a multifamily unit. That's going to be a violation of your covenants, and you can utilize the fire marshal to help you. You can utilize the Department of Public Health to help you. But don't be taking on things that are not your job. I mean, fire and flood, most of the time, if it's a fire, it's not the HOA, call the police. If it's a flood, that's one that the HOA, if you can turn off the water to stop the flood, great, wonderful. But if it's a flood from like the river next door, that's not yours. That's a hazardous situation. And it might be one that you can help your community with. You know, you might have a whole bunch of people evacuated. Okay, fine. Set up a website, send up access so that you can help them and help the authorities share that information. But don't take on obligations that aren't yours. There's a couple questions I want to answer real quick. Somebody said, I thought it was 30 days and a second notice of another 30 days before fine. 1137 is 30 days to fine and a second 30 days before you can turn it over to council. So you only have to go 30 days before you can get to that first fine. What about open fires or grilling inside the garage? Look to your documents on grilling inside the garage and see if you have something in your provisions that say owners shall not take on any hazardous activities, and use that as your covenant enforcement. I don't know that the police would come out for grilling inside your garage. Open fires, it's going to depend. You might be able to use the police or the county. Right now, we've had so much rain everywhere, there really aren't any fire bans. And so you're probably going to have to be dependent upon your documents. And if your documents specifically, a lot of big acreages have like no open fires, and that's going to be a covenant enforcement. But again, 1137 is going to tie our hands. You're going to get that first notice out, and you're not going to get any second ones. So I went through a whole bunch of things really fast, and I think I caught up with all the questions as I was going along. I know one other person had asked a question and I hit most of it, but it was about dogs. And the question was, what about if packages are delivered and they go missing? It depends on where the packages are. If the packages are coming to the front counter of a condo, then you need to kind of create a policy on whose responsibility it is. And if your front desk condo has a person there all day to accept those deliveries and is willing to take that on, then you need to be responsible for it, because if you're not responsible for it, then the homeowner can come after you. If it's just delivered packages that are going missing on people's front porches, that's not yours. Again, if somebody thinks they saw who did it, tell them to call the police about it. There's not much you can do about that. I think that's all the questions, other than the one that was way too detailed for me to dive into. So I hope I've answered all your questions, and you guys all have a great afternoon. Oh, if someone leaves their dog poop out on their patio all the time, is that health and safety? No. That is not health and safety. It just smells. And it's going to fall under if it sits there for 30 days, it could be an odor violation, and you could exceed your 30 days and get to a fine stage. So thank you very much to everybody. I think we're done, and I got through all the questions, so have a great afternoon.